So a federal bill has just been introduced to restore the Second Amendment rights of marijuana users in states where marijuana use is legal. So let's talk about this. But real quick before we jump into this video, if you don't like the federal government telling you what you can and cannot do, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main sponsors of the channel, that is USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a firearm, I highly recommend you look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, a federal bill has been introduced which seeks to restore the Second Amendment rights of marijuana users in states where marijuana use is legal. This proposed bill is HR 2830, also known as the Gun Rights and Marijuana Act, also known as the GRAM Act. And the GRAM Act has been introduced by Representative Don Young out of Alaska. And it has also been co-sponsored by Congressman Brian Mast out of Florida and Rodney Davis out of Illinois. So as of right now, those are the co-sponsors and sponsor of this bill, the GRAM Act. So what does the GRAM Act do, and how does this interplay with marijuana use and also your Second Amendment rights in firearms possession and purchasing? Well, this all involves you having to fill out a 4473 when you purchase a firearm. And so when you go to the form 4473 and you go to question 21 subsection E, this states that, and it also requires that the individual attest to the fact that they are not an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance. The form also then goes on and clarifies specifically that the use or possession of marijuana remains unlawful under federal law, regardless of whether it has been legalized or decriminalized, specifically by any state or tribal area. So essentially under this form in federal law, the 4473 says regardless of what state law says or what your tribal law area says, if you possess or use marijuana, you cannot go and purchase a firearm. And if you were to fill out this form 4473 and attest to the fact that you don't consume or possess these items, when you do, you would be perjuring yourself. Well, the GRAM Act seeks to actually change this and actually add in an exemption for those individuals in states where your state has said that you can lawfully possess and consume these items, or maybe where your tribal area says you can lawfully possess or consume these areas. It will create an exception for you. Now, this isn't going to be some sort of federal standard, but essentially what it's going to say is we're going to carve out exceptions for those individuals in states where your state has taken upon themselves to say that you can lawfully and legally engage in this conduct and consume these items. And what's interesting with the GRAM Act, this is kind of an interplay both between Second Amendment rights as well as 10th Amendment rights and state rights. Now, if you're not familiar with what the 10th Amendment is, I'll read it for you right here. It says that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. So essentially saying that what has not been delegated to the federal government by the Constitution remains in the states and the people. Now, as we've seen very recently, many states, including the state of California, have taken it upon themselves to legalize marijuana use, consumption, possession in certain amounts, things like that. But again, this has created a weird issue because at the federal level, marijuana possession consumption is still illegal regardless of what states say, and especially in this Second Amendment context here, when you fill out the 4473, federally consumption and possession is still illegal. Now I'm going to read to you real quick some quotes from Mr. Young, the sponsor of this bill, as well as some of the co-sponsors. So Mr. Young states that when I was sworn into Congress, I took an oath to defend the Constitution of the United States. That oath does not mean picking and choosing which amendments to defend. It requires us as members of Congress to protect the entire Bill of Rights. I'm very proud to introduce the GRAM Act, which takes a critical step to protect our Constitution and to secure individual liberty. There are two main pillars that make this legislation important. First, it protects the Second Amendment for individuals who seek to exercise their constitutional rights. It also protects the 10th Amendment right of states to determine their own cannabis laws, as Alaska did in 2014. Gun ownership is a significant part of Alaska's culture and lifestyle. When my constituents chose to legalize adult use marijuana, they were not surrendering their Second Amendment rights. At a time when more individuals have been purchasing firearms for self-defense, sportsmanship, hunting, and countless other reasons, we have experienced a surge in state-level cannabis reforms. While we make progress in some areas, it is vital that we do not roll back progress in others. He then goes on to state that the federal government has no business unduly restricting responsible citizens from exercising their rights or restricting states from listening to their constituents and reforming marijuana laws. The Graham Act bridges this gap. Given that it deals with both gun and marijuana rights, there really is something for those on both sides of the aisle to support. Now, when you look at comments from some of the co-sponsors, this is coming from Congressman Mast. What he states is it should be up to the individual states to determine their own marijuana laws, not the federal government. The Constitution says nothing about marijuana, but the Second Amendment clearly outlines every American's right to bear arms. This legislation makes it so individuals who use marijuana in states that permits legal adult use are still able to purchase firearms. Congressman Davis states in his quote that state legal marijuana use should not be used as a pretext to bar individuals from purchasing or possessing firearms, which is a clear and well-defined constitutional right. I've long believed that laws regulating the production and use of marijuana should be left to the states, not the federal government. With more and more states legalizing marijuana each year, we have to make sure that we are protecting the Second Amendment rights of Americans who reside in those states and use marijuana legally based on their state laws. I think generally this is much needed relief for some individuals in these states who kind of find themselves in limbo, and generally I'm more in favor of leaving things within the hands of these states rather than giving it up to the federal government to decide what states and the individuals in those states should and should not do. This is definitely one of those weird issues because you're dealing with marijuana use, states' rights, Second Amendment rights, and so there may be a lot of representatives who do not want to jump on board with this because they are concerned or maybe don't know how their constituents fall on this issue. So if you support it, I highly recommend you reach out to them. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you guys like this video and you would like to support the channel, one of the best ways to do that is to like, comment, subscribe, and make sure that notification bell because that helps the channel analytics, especially right now with YouTube trying to suppress my videos and just not let it get out there to the people who want to watch it. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars. This nation will be maintained by armed scholars.